Imagine being on the job doing tough, hard work, day in and day out, and your coworker walks up to you and starts a fight. You throw a punch, but get knocked down to the ground, injuring your back. But when your injury is so bad, you're suddenly unable to continue working at all. But what's worst of all is that when you go to the insurance company to file a claim for your medical bills, they deny your claim. Well, that's exactly what happened with one of my clients several years ago. A young man in his 30s, who I will call Rocky, who suffered an injury on the job. Did you know injury sustained at work as a consequence of an attack by a coworker can be compensable? The exceptions would be when the attack was a result of non-employment related hostility, the assault was a deviation from regular work duties, or the injury was a result of horseplay. It turned out Rocky was not an innocent victim of an unprovoked attack in the workplace. The evidence showed Rocky had previous physical altercations outside the workplace with his coworker, Apollo, and this fight was a continuation of that feud. Rocky, by throwing a punch, became a mutual combatant and no longer an innocent victim. If you become involved in a workplace altercation and attempt to defend yourself with aggression, you're likely to have your claim denied. It is best to walk away from such instances. However, if you must defend yourself, do not become the aggressor. I'm Craig Armstrong, and since 1983, I've been helping Oklahoma residents who are injured at work get the proper compensation they are entitled to receive. If you've been injured at work and have an insurance claim or Social Security claim, and are being pushed around, visit my website and set a time to meet with our firm. Also, if you need more information about workers' compensation, check out the rest of my videos on my site and channel. Imagine you're a hard-working, devoted office worker, and your employer wants to reward your hard work with an office picnic, an afternoon of recreational games, and will pay you for doing so. But while you're enjoying yourself and having a good time with your coworkers, you take a bad fall playing a game. Your injury is so bad you need surgery, and you are suddenly unable to continue working at all. But what's worst of all is that when you go to your employer's insurance company to file a claim for your medical bills and lost time, they deny your claim. Well, that's exactly what happened with an individual I'll call Mimi, who contacted my office several years ago. Mimi was a young woman in her 40s who suffered an injury while at a company-sponsored Friday afternoon picnic. She was a secretary working in an insurance office. The company had an annual picnic taking place on a Friday afternoon at a city park. Attendance was mandatory, but all staff were encouraged to attend. All those attending would be paid for the afternoon. Those not attending would remain in the office. Mimi argued to the insurance company that the company encouraged her to attend and they paid her for the afternoon she was at the company picnic. Unfortunately, regardless of the employer's good intentions, they are not responsible for Mimi's injuries. Injuries sustained engaging in or performing any recreational or social activities for the employee's personal pleasure are deemed not compensable injuries. It didn't matter that the employer paid the employee's wages for the afternoon. At the time of the injury, Mimi was not performing essential functions of her job. Exceptions do exist where recreational activities performed in the workplace could be considered compensable. I represented a physical education instructor who I will call Coach. He was participating in a physical education activity with his students when he sustained an injury. The insurance company initially questioned the claim and denied the claim based on the non-compensability of injuries that are sustained performing recreational activities. However, the distinction I was to show in Coach's case was that as a physical education instructor in a public school, an essential function of his job was to demonstrate and participate with the students in the performance of sporting or recreational activities. I was successful in getting Coach's medical expenses paid and got him compensation for his time off and permanent injuries. If you need more information about your workplace injury or Social Security claim, check out the rest of my videos on my channel or website. We make videos like this educating workers of all their rights when it comes to workplace injuries or Social Security claims. If you've been injured at work, schedule a meeting with us today and let us help you create a plan to get the compensation you're really entitled to. I'm Craig Armstrong, and I look forward to helping you.